Welcome to I'm Too Busy, an interview-based show hosted by a talented makeup artist, Christina Flach. Christina offers viewers a unique blend of personal stories, inspiring journeys, and practical beauty tips. Join the conversation as Christina features successful individuals from various industries who share their insights on health, wellness, makeup, and the keys to their success. So now, please welcome the host of I'm Too Busy, Christina Flach.
Hello, I'm Christina Flach, and welcome to I'm Too Busy. Today, we are spotlighting an individual that is one of San Francisco and the country's leading distinguished legal minds, a champion for justice who has spent over 4 decades fighting for those affected by catastrophic injuries. I'd like you to meet Scott Righthand. Hello,
Hi,
Scott.
Christina. How are
How are
you?
you? I'm great. Good to see you, as always.
I agree. It's always great to be with you.
Thank you. So I met Scott after my husband, Ken Flach, passed away from sepsis almost 7 years ago. My husband was a former professional tennis player that was not seen by Kaiser Permanente doctors. And because of not being seen and treated, he needlessly died in the prime of his life. I was referred to Scott by my friend, Gina DeVito, who told me, if you can get that rock star to represent you, it will be a miracle. So go talk to him. So I went and met with Scott, and then I instantly knew that he was the one that I had to represent me. And thank goodness he did. And that started our 4-year journey together, in this lawsuit I had against Kaiser. And I always knew that Scott truly cared about justice. It wasn't just a money thing for me. I know I hear a lot of people saying, oh, lawyers are just out for the money. Scott is not like that at all. He couldn't have been kinder, more empathetic. He was just extraordinary, besides being incredibly brilliant. And so I'm really excited to have Scott here today to just talk about all things about the law.
Oh, thank you so much, Christina. That journey that you and I had was really a highlight for me. It was 4 years of a fascinating time and a hard fight, and the fact that it came out as well as it did at the end was just the icing on the cake. Um, but your input and all that you brought to the table was, was everything in that case. It just made that case. So,
Well,
a lot of
thank you.
hats off to you about that.
Well, it was all you and your guidance. It was a lot of ups and downs and all arounds. A legal case is one of those things that until you're in the situation, you're in a partnership, because you did this case on contingency. So if we didn't win, you spend a ton of money on the costs and the fees, everything. So I would imagine that it's really something that you have to be very mindful when you're taking on a case, that you have to be really confident that you're going to win, because you don't want to my legal fees and everything was almost $800,000. So that
Exactly.
could have just been lost. So is that a hard thing for you to determine who you take on?
Well, so this has been my life, really. My business is entirely that way. So I've never billed an hour in the last 40 years. All of it is contingent fee work, and all of it is because I believe in the case that comes in the door. I've assessed the case and value it, and have to assess it and work it up and make sure that it comes out the way it's supposed to come out. Because obviously, if I'm working on 50 or 60 cases at any one point in time, which is what's in the law firm, you can't pay attention to all of those cases every minute of the day, every day. And so you have to do what needs to be done on those cases when it needs to be done, and you have to make effective decisions as to which cases you're going to do. And so your case, was a little unusual, because medical malpractice cases, which I do my share of, are among the more difficult of cases to do. And oftentimes, there are defenses and things that come up in those cases that you never really anticipate. And so you sort of have to think ahead about 10 steps on those cases to make sure that they do come out the right way. So yeah, choosing cases is a big deal.
Yeah, because I remember after I had won my case, Scott, I was referring Scott to anyone that would call me, which was every day I was getting emails and calls. And Scott was like, I love you that you're referring me jobs, but these are dogs. Like, I'll never take them. I can't sit and listen to every, person call me about some story. So I had to like be a little mindful when I would speak to people and say, like, look, if there is no, and unfortunately, so this is something interesting that we can talk about. California is different than a lot of states. There is at the time when I had my case, there was a $250,000 cap on malpractice. And now it's up to 300,000. And the only way that someone is going to take on a case if there is, a financial loss. And so
yeah, it's been an interesting ride. It's true that in California has caps on what's called non-economic damages, which are, in your case, say if you lose someone that you love, like you lost Ken, there is a value to the loss of love and affection and everything that Ken brought to the table emotionally to you. And I know he was the love of your life, and to attach a $250,000 cap or it's now I think up to $390,000, but to attach even that to a loss as substantial as the one that you experienced and many of the people that I represent experience in medical malpractice cases, it's outrageous. And it's been that way since 1975. So, that's.
Do you think that's ever going to change, or what are other states? I don't know what the laws in other states are. Is this in every state, or is it just California?
It is in many states, not all. Every state makes a different decision about it. And California, there was a time years ago where the California Medical Association, I guess, along with many of the insurance companies that represented doctors, basically sent out a scare bulletin to everybody that they needed to pass this law. And if they didn't pass this law, all of the doctors were going to be leaving California and nobody would ever be able to have get their care in California again. And because all of the insurers would leave California and the doctors would be uninsured, and on it went. And everybody bought that lock, stock, and barrel, at least the legislature did. And that's what came to be the result of something called MICRA, the Medical Injury, I forget what an acronym is, but Reform Act. And that was the $250,000 cap, among other limitations on malpractice too. So, it's just an outrageous thing. For example, if you're hit by a car in California, or if it's a trip and fall because the city, didn't remove the root from the sidewalk or whatever it might be, there's no cap on those non-economic losses. And the problem is if your injury happens to be because a doctor, acted below the standard of practice, there is that cap. And so we have to choose cases in the area of medical malpractice because they're so expensive to do and so hard to do that have a significant economic loss. And, fortunately for you, because Ken had a history in professional tennis, we were able to put together an economic loss for him that made, doing this case economically meaningful for both of us.
Mm-hmm. Do you think that's ever going to change in California, or do you think that's going to stay? And do you think it's fair?
I think it's one of the most draconian, unfair laws that I've ever seen. And I don't see it changing. Just in the last couple of years, there was the first change since 1975 in that law. And that changed the law, increased the cap on non-economic damages I think it's $50,000 a year now, and plus there's a little bit of a cost of living increase. Every year it goes up a little bit. So it is going to change, but it's not going to change to the point where you actually can recover your real losses and the total full value of those real losses. It's always going to be artificially capped. In my view, I don't think it's going to change more than it has now, at least, in the next 10 years anyway.
A big thing for me moving forward with this case, one of the reasons why I did was because I wanted there to be change. I was with Kaiser Permanente for 2 months before my husband passed away. And one of the big things for me was I really wanted to make change in their way they don't see patients. They factor into their business plan economic loss from people passing away, and because they don't want to have their doctors seeing patients. And I think for me, that was a big deal that I hope made some change in how they take care of their patients. I also think they have, and I don't know what your thoughts are on this, but with Kaiser, for example, it's kind of a conflict of interest because they're an insurance company, but they're also doctors. And then they also have you sign something that says you have to go through arbitration if anything, God forbid, happens, which you don't know about until something horrific happens and you find out.
Yes,
which benefits them clearly.
Exactly right. Everything that you said is entirely accurate. You have to go through arbitration. You have to go through the process of locating an arbitrator. Not locating one, but choosing an arbitrator amongst a sea of potential arbitrators, many of whom I think have some already pre-existing biases given the nature of the system, because where Kaiser is a repeat customer for all of those arbitrators, the people who get hurt are basically one of a kind. So where the interest, it's these arbitrators get paid, well to do these cases. And so a lot of them make a career over it. And, many of them, have an interest in making sure that Kaiser does not blackball them by them issuing awards or verdicts that are in favor of Kaiser, or, basically inadequate in damages or inconsistent with what the law is. So, there's that problem with the arbitration system. There's the problem with the caps on non-economic damages. There's, what you said is 100% true about Kaiser in terms of how it operates its programs. And it does so in a way to really everything about Kaiser, in my view, is intended to increase their bottom line and minimize the care that they provide for people who are signed up to be Kaiser members, which
Right.
is basically a sad state of affairs. I mean, in your case, in Ken's case, you could hear there was a phone call that I'm sure you remember between you and Ken, and
13 minutes with the advice nurse.
Exactly. And you remember how that nurse essentially did everything she could to shunt you and Ken away from seeing a doctor, so that the interaction came down to essentially a 2-minute or 3-minute phone call with the doctor at when Ken was really in trouble and needed to see somebody immediately and probably should have been in the emergency room. I mean, not probably, 100% should have been in the emergency room hours before he was. And they basically, found ways to get Ken not seen by doctors and to talk to a physician for 2 minutes at the end. And regrettably, that may have cost your husband his life. It was one of the saddest things that, stay with me. And I know it stays with you every day.
We are going to be right back with Scott Righthand after a commercial break. I'm Christina Flach, and I'm too busy. Hello, I'm Christina Flach, and we are with Scott Righthand, chatting about all things in the law. Scott, you've had multiple cases against Kaiser Permanente. Is that true?
It is true. I've had many.
And do you see anything changing in any of your, these cases with them, or is it constantly just the same thing over and over again?
You know, this is one of the problems with this industry because there basically is a screen by way of insurance decision making to pay out on many of the good cases and limit the cases that come to arbitration and come to trial. Kaiser keeps doing what it's doing, and I don't know that there's been any dramatic change. And if ever there was going to be one, I would have thought that following what happened in our case, there would have been a significant change because, you know, God bless you, you hammered them for years.
I was the worst. What did I tell you? So just a little backstory. After Ken passed away, I was asked by the Sepsis Alliance to raise awareness for sepsis. And so it was like my mission to just keep doing these podcasts until Scott goes, "Why are you doing this?" And I said, "I'm going to keep doing this until they tell me to shut the fuck up." And as Scott knows, I never shut the fuck up. And so because I really was so angry that they would not see him and that he needlessly died. And so I would go on any podcast that would have me, and I would just go on. And I just kept, and Scott and I were even laughing. We were like, how have they not gotten the judgment to shut me up? Something. It's like they weren't even paying attention. It was crazy.
It was unbelievable. I mean, Christine, you appeared on every show, every place. Ken's picture was postered all over BART and all over the Bay Area, all over everything, as this could happen to you, and then they would interview you, and you would essentially tell it like it was. That Kaiser refused to see Ken, and it cost him his life, and don't let that happen to you or your husband or your wife or somebody that you love. And you made a big impression, I think, on the entire Bay Area, and the fact that Kaiser, you would think that they would have maybe changed something, but the economics are so powerful for them to not change anything. It always comes down to that. I'm sorry to say.
No, it's really remarkable. And so have you ever had cases that have turned upside down? I mean, I was really adamant, and I felt like I had a commitment to you to be my best self because we had this partnership going on. I couldn't, have you spending hundreds of thousands of dollars on this case if I wasn't going to stand up to my part of the bargain as well. And have you had clients that you've represented that haven't really done everything they can do to make it easier for you?
Of course. I mean, usually, it's rare that we get people as committed to the partnership, if you will, as you were. But most people essentially, turn most of it over to us, or all of it over to us, and you did too, because most of it you can't do. But your interest and your continuing providing information when it was necessary, and access to different expert witnesses, and your knowledge of the tennis industry and so many things that you knew about were really major contributors to making your case go. And it's crucial to every case that there's participation by the person who suffered the injury, and not just passive participation. So, yeah, we've had cases that I thought that when I took them, I was pretty clear we would come out in nice shape on them, but we didn't get the participation from people. But sometimes things happen in cases, and what you, especially in medical cases, and what you believe to be the way things went down maybe wasn't at the end of the day. When you actually see the medical records and dig deep into them and consult with your experts and all that, you see that it might not, be exactly the way that you thought it. So it's kind of a moving dynamic, issue on all these cases. But the thing about it is, really, you have to have a vision when your client walks in the door. Like when you walked in the door, I remember it very, very clearly. I knew how committed you were. I could see that there was real potential in this case, and real potential, both economically and on the liability component of it too. That I did not think what Kaiser did was right, and so you have to believe and take that vision and follow it to the end of the day, and all the way to judgment if need be. And that's really, I think, one of my strong suits, and I think that's what you have to do in this business. You have to believe that when your client walks in the door, that you can bring that case, in either a judgment or settlement or whatever it's going to take to make it happen and get full value for the case.
I think that I just always felt like so protected, and that you were so prepared. And I didn't feel that, because we went through a couple changes with the opposing counsel. The first lawyer he got ill, his eyes went, he had a terrible surgery and something happened, and we got someone else. And it just seemed like they were not quite as prepared as you were. And I always felt like when you would cross-examine, I'm like, oh, watch out, he is going to kick your ass. It's just I was like Diet Coke and popcorn. I could just watch this all day. Watching you do cross-examination, it was so great. But I also think what you did that was really strong and really important, you really made sure that our arbitrator, who was an ex-judge, I really felt that he was fair. I don't think he was 100% on my side, or he wasn't on any side. He was really fair. And I think that made the hugest impact, your selection of the arbitrator.
That was a huge deal. And Judge Sullivan is one of the fairest jurists. He is an ex-judge, and he did go out of his way to make sure everybody got, their absolute fair full day in court. And there are many arbitrators that won't do that. So one of the key things in Kaiser cases is, who is your arbitrator? It's just like picking a jury, except there's only one person that's going to, decide the case in an arbitration. And, when you're picking a jury, there's 12 in California. So, I think that one of the most important things in the process is either picking an arbitrator or picking the jury. And everything, it is going to go one way or the other after that. So if you have a good case, you have a fair arbitrator, you're going to win. You have a good case, you have, a reasonable jury, you're going to win. But if the equation doesn't come out that way in any single case, where either your arbitrator, is the wrong one, or you don't spend the time vetting your jury, that could be the end of your case. And I've seen it happen.
Do you deal mostly with arbitrators, ex-judges, or is a lot of your cases with full juries?
Oh, it's more juries than arbitrators. So,
and do you prefer that?
Yes. It just everything depends on the situation. I prefer jury trials generally, because they're more dynamic. There's more that you can do. You just feel like you're not so limited to the decision making of one person, that the 12 people make the difference. And if there are some people that disagree, there's give and take, behind the scenes with the jury, as to convincing each other or one another as to which way the case should come down. But with an arbitrator, it's just however that person happens to see it is how it's going to be. So it makes it a little difficult.
How long does it take you typically to select an arbitrator. I mean, I remember in our case, it took a while because we liked one and then they didn't want one. And, we were really lucky to get this particular one, because if we would have had one that was not fair,
would have been all the difference.
Totally. Or someone, doesn't like, they kind of have to, at least I think, respect and like you a bit, the judge.
They do.
You don't want someone that, finds you distasteful or annoying. So even I had to zip it and behave myself. I had to cry when it was appropriate, be tough when it was appropriate, and shut the fuck up. As Scott would tell me very nicely, Chris, I love you, but shut the fuck up.
Well, I remember, at a point in that arbitration where, you were, in clear view of the judge.
Oh, yeah.
You were eye rolling, and we
seething
during the break. We had a conversation about that.
Yes, we did. And he's like, I get it. I know. But you know what? You have to behave, because if you don't, this judge is going to hate you. And this is going to go all wrong just because of your attitude. And so I really had to be like, okay, do I want to be right? Or do I want to be happy in the end? And so it was it was a conversation that needed to be had. But that, again, was part of the commitment to the relationship. If I wanted it to go well, I had to play nice in the sandbox.
Well,
and
exactly,
it's really
right.
hard. It is really hard sometimes when you're seeing injustices and lies being told, and you have to just sit there pleasantly. And I have had to learn, self-control over my emotions and not show them. And, it was an up and down roller coaster at times.
Exactly. Having done this for so many years, you just have a sense of who the arbitrator is, or who what the jury is like, having picked them, and you have to guide your client through the process so that they're, so that they can just be who they are, but still do so within the parameters and the framework that's going to make the biggest impact and win the case. I mean, that's my job, part of my job. Mm-hmm. But one of the joys of this business is that there are so many components to this job, as you've seen it. It starts with the gathering of information and the consulting with the right experts. And as you remember from this, we had experts in this case that were physicians who were the best of the best of the best.
Oh, they were amazing.
Right? Incredibly
they were amazing.
Right.
And they were worth every penny, because, the opposing, their experts weren't as good.
Exactly right. And they make, in a medical malpractice case, they can make all the difference. They do make all the difference. So they have to make sense. And then, your job is to also get them all the information that they need to have, so that when they take the witness stand, they know what the theories of the case are, and they've read the records, and they can rely upon the records, and also rely upon their expertise, and get said what needs to get said. This is all behind the scenes. I mean, no one knows what transpires between a lawyer and his or her expert, coming up to the time of trial or arbitration. And so you have to prepare your expert like none other. And there's a lot of back and forth that happens during the process, because these are not puppets. We're talking about the highest quality of doctors, because that's what you need, because the defense has tremendous access to the universe of physicians, because they represent doctors. And it's very easy for them to find other doctors who will get said what they want them to get said.
But, it was also interesting. No, it wasn't. But what was interesting, I remember during our case, was you finding expert witnesses that didn't even look at the case and would just testify on behalf of Kaiser because they were getting paid. And you expose them every time. And, and then the physician that we were suing, he was ill prepared, which was really surprising, especially because Kaiser has an endless supply of money. We had whatever Scott's American Express could afford to pay all these people. So it's not that, I can't tell you how many people told me there is no way you're going to beat Kaiser. And I go, oh, you just watch. Scott is going to kick their ass, and I'm not going to stop until he does. How long does it typically take a case from kind of beginning to end? I mean, ours was over 4 years, but is that a normal amount of time, or is it more? Is it less?
It depends on the situation and the case and what's happening in the process of the case. So I would say that's a long time. Most of the cases resolve in about 2 years. I'd say the average, maybe 2+ years. Medical cases can take a lot longer, and it can vary because the people, people's health and there's so many components to what drags a case on. So if you got 2 or sometimes 3 or sometimes 4 sides in a case, there's lawyers' calendars, there's judges' calendars, there are experts who can't be there at certain times. There are so many things, and when you put 3 or 4 different people and experts and judges and courts together, it doesn't always get done in a year or a year and a half. A lot of times it takes longer, and that's so frustrating for people, I know, to have to live with a case that goes on for so long. It just depends. But the other thing is, there are a lot of lawyers who will turn a case over pretty quickly, and you can potentially do that if you're willing to take less than value for the case. But that's not my interest in doing this business. My interest is, making sure that my clients get value for their cases, whatever value is for that particular case, and everyone's different. But it's not what we do to essentially walk into a case, settle it the next day, and go on with our business and let the client take 10 cents on the dollar for value of the case. It's not appropriate.
Right. Can you share a case that fundamentally changed your approach to practicing law?
Interesting. Not really. I would say my approach to practicing law has essentially been the same. I will tell you that, there are times where things have happened that, the approach has had to be altered, and it never works out well if the approach has to be altered. But my approach has always been, from day one, to do my best to choose the best cases that I possibly can, because there's no percentage in it for anybody to work on a case that is unlikely to win. There's no point of it, and so it starts there, and then the next process has to do with finding the appropriate experts to evaluate the situation, whether it's a products liability case or a medical malpractice case or a slip and fall case. There's experts involved in all these cases, whether it's a plane crash, a train crash. I've done, pretty much every kind of catastrophic personal injury case there you can imagine. And it all comes down to knowing more than the person who's sitting across the table from you when you take their deposition, when they're the opposing expert or the opposing witness. It comes down to doing everything you can to learn what the answer to the question is and figure out why you've assessed the problem the right way, or if you haven't, what to do to change your assessment and change it quickly and effectively to get it done the right way. So it's all about preparation and hard work. And I would say that, I might not be the smartest guy in the room, but I may work harder than anybody else.
So tell me a little bit about the appellate cases that you've had.
Well, one of the cases I am most proud of is a case that has a title, Randy W., I think it's versus Muroc, and it was back in the 80s. And that case went to the Supreme Court of California, and it has been cited over and over again in almost every jurisdiction in the country, in other countries. And so, one of the amazing things about the business is, if you see the practice to the end, to where it needs to go, amazing things happen to your clients, to other people who maybe use that precedent as something important in their world, and to you as well. So, it's not, my theory of the world is always, as you mentioned earlier in the conversation, it's never been, follow the money. It's always been figure out what the right thing to do is and do it with everything that you've got, and, leave no stone unturned, and try to make sure that at the end of the day, you've, given everything to make sure that your client comes out whole. So, that's the process that I live by. Well, this case, this is years ago. It's in the 80s.
Mm-hmm.
This case was a young girl who got molested by her vice principal down in the valley, in the Fresno Valley. And apparently the principal had been at other schools and had similar problems at other schools, and was recommended for another job at a school down the road. And letters of recommendations were sent out regarding this guy, and they basically said, this guy is an amazing guy. He's the best and the brightest, and he will be a fabulous addition to your school and all that. And they knew that this guy essentially was a sexual predator, and was a sexual predator with children. And so, of course, relying upon those references, school down the road hires this guy, and he does the same thing and molests this child. And so we brought a lawsuit against the people who wrote those letters of reference. And the trial court down in Fresno basically threw us out of court and said that, letters of reference were just that. Nobody relied upon them. We couldn't prove that, there was adequate reliance by the school down the road and all that. And it was just my case. And I did it from start to finish. And I argued that before the California Supreme Court. And they had a unanimous decision that is impacting, these issues very much so to this day. And so that's just one example of an appellate case that I'm extremely proud of. There are a couple of others that we've done over the years. So, my theory has always been whatever it takes to, get the answer and make sure that you can get justice accomplished is what you got to do, because that's what you signed up for. So if you lose the case and you think that you shouldn't have lost the case, then you need to appeal it. If you lose the case, and I've lost my share, and you recognize that there was good reason you lost the case, there may not be reason for appeal. But if you have a legitimate reason to appeal a case, in my view, you're obligated to do it.
Oh, definitely. How often does that happen? I mean, I'm sure you learn something from every one of your clients. I know for me, Scott and I would have a joke, because I'm like, Scott, you would say, Chris, I'm really worried about this. I'm like, Scott, focus on what you want. Angels will watch over us. And you're like, you're so weird.
Actually, no, I was not. I learned a lot from you in that case, because you were among the most committed clients I've ever represented. And you have a focus that is dramatic. And like I said earlier, I have a vision of my cases when I take them, and I keep that vision in mind throughout the entirety of the representation. And you had a vision of what you wanted to happen in this case, and you were not going to be denied. And I think it was a huge impact to what happened in this case. So, my hat really is off to you in everything that you did in that case. Yeah.
I appreciate that. I hope you still know that angels are watching over you in all your cases.
I do.
Well, so
I
see, you learn something from everyone.
think about that all the time, Christina. I really
Do
do.
you now? Well,
I
I'm
do.
glad to hear that. I'm glad to hear that. What innovations have you brought to the field of catastrophic injury litigation?
Well, I mean, I don't know about innovations, but I always try to stay steps ahead of where the process is going. So, I always try to read everything I can read on the subject matter. I try to retain the most qualified and innovative experts who understand the process, whether it's, what happened at an intersection where there's a train automobile collision and why the visibility problems weren't what they were, or what happened when Harley Davidson, decided to do business with a vendor of electrical wiring down in Mexico. I've got to find that person who knows more about Harley Davidson than anybody else, or more about, visibility and lighting and train approaches, and how people view them and see them, and than anybody else. And I need to know that early in the process of the case so that it can guide me in how I depose the witnesses and what I do in the case. And I don't know if that's innovative or just, basically, elbow grease, just, rolling up the shirt sleeves and making sure that the work gets done and gets done a lot. So I don't know if it's innovative. It's just commitment, and it's just belief, it's more belief in the case and the justice and the clients than it is in anything else. And I try not to take cases where I can't, I can't muster that belief, if you know what I mean. It's like,
Right.
client walks in the door and I don't, there's something that, isn't right about it for me. I try not to do that case.
Right. We're going to be right back with Scott Righthand. I'm Christina Flach, and I'm too busy. Welcome back to I'm Too Busy. We are with Scott Righthand today, chatting about the law. Do you see yourself doing anything else? Or do you ever think you'll retire from this? Do you ever just go, oh my God, I've had it dealing with these scumbags and people that lie? Because that's one thing that's really hard for me dealing, going through that lawsuit, was just that they could say things that were just completely untrue.
It's true. What you're saying is 100% accurate. And a lot of it drives me. It's one of the joys I have. And I mean, I realize it's bizarre to call it a pleasure or a joy, but I love to sit across from, an expert or a doctor or, somebody that, is just either not telling the truth and I know it, or is just skirting the edges of the truth and I know it, and I can, find a way to make sure that it doesn't stay that way at the end of the deposition. It's such a pleasure in life. And that's
I bet.
so hard to walk away from.
I bet, because, it's a moral thing. It's really, what do you do when your day's not flowing? Like when you just are like, oh my God, everything's going wrong. What do you do? How do you handle a day like that?
Great question. So, sometimes I just have to walk away from the day.
Mm-hmm.
Sometimes I'll go home. I'll hop on my motorcycle, which is one of my avocations, and take a ride out to the beach and ride up the coast. Sometimes I'll pull out the mountain bike and ride up Mount Tam and just spend a day, just enjoying, everything that's around me. Um, my life is full, and it is. I wouldn't have it any other way. Uh, I don't want to walk away from any part of it right now because it's just so interesting. It's, there are things in the practice that are so compelling, and there's so much pleasure in the stuff that I do that's, not law, and just fun and travel and motorcycle and just have a time.
Where's your happy place?
Great question. I'd say it's on the motorcycle. Kind of a great place to be on a beautiful sunny day out at the coast, headed, through and around beautiful roadways. And I took a nice little motorcycle trip with my son, who also rides this summer down, and we rode up through from New Orleans up through Mississippi and into Nashville, and just loved every second of it. So it's being with my kids, it's being on the motorcycle, it's being with my wife. It's just it all those places are good spots for me to kind of wind down a little bit and get ready for the next fight. So it's I would say I do not have a good work-life balance.
Okay.
I do
So
not.
what?
It's
Yeah, it's
much
hard.
more.
It's challenging. It's really hard. I just feel that self-care is so incredibly important because it's not selfish, because you need to be able to exercise, you need to be able to be rested, you need to be the best you can be for you to give the best you can be. So I know that it's really challenging. What do you find to be the most challenging aspect of running your own law firm?
The most challenging aspect of running your own law firm is running your own law firm. You are like a one-armed paper hanger. It is incredible. You've got to deal with, the experts, the vendors, the people that the court reporters that have to have to do the depositions for you. You have to deal with your staff. You've got to do all the millions of things that you have to do besides practicing law. So it
Right.
is.
It's like having a business within a business.
Oh my goodness, it's crazy. So that let's just say that is really hard to do. And when I decided to take it on, I was, I don't know, 35 years old or something like that. And I, I was really energetic about it. And I really was interested in, seeing all the processes of how the business ran and all that. And, and so now, having lived with it, let's just say it's harder to run your own business as a lawyer than to just be an employee somewhere at a law firm, because you can just concentrate on,
On
whatever
one
case.
thing.
Yeah,
Right.
exactly.
What do you think your most memorable courtroom moment has been?
Hmm. Um,
Or one that comes to mind?
but just, I would say the most memorable courtroom moment was a remarkable cross examination of an expert where I could tell that this expert was going to cost me this case. And I was able to turn it around, and I could look at the jury and know that right at that point I was going to win that case. I'll never forget that. It was down in Fresno, and I remember the case very well.
Hmm. Where do you see your life in 5 years?
5 years. I'd say in 5 years, I'm going to be doing maybe 2 or 3 cases a year, spending a lot more time on my motorcycle and traveling and maybe doing this business perhaps 20% of the time instead of the 90% that is happening right now. So that's what I'm looking forward to. Looking forward to maybe seeing my kids a little bit more. They're older now. They're in, one of them's in LA, one of them's in Texas, and I love them like none other, and I'd love to spend a little more time with them. So that's kind of how I see it all happening.
Scott, thank you so much for being here. I'm so grateful you're my friend. I'm so grateful that you were there to protect me from Kaiser.
Christina, I feel the same way. You are a delightful person. You've been a great client, and you will be my friend forever.
Thank you. I want to thank everyone for being here today. I want to thank Dan, my engineer, Maya, Avery, and he who shall be nameless that makes me smile and laugh every day. Thank you so much. I'm Christina Flach, and I'm too busy, and I'll see you next week.
This has been I'm Too Busy with host Christina Flach. Tune in each week as Christina approaches the concept of success holistically, recognizing that achievement is not solely measured by financial triumphs, but also by maintaining a healthy work-life balance and focusing on self-care. Wednesdays, 7 p.m. Eastern on the Bold Brave TV network, powered by B2 Studios.